there is a lot of discussion nowadays what should be the proper role of the human rights courts, not only the human rights court, European human rights court, but human rights courts in general, and what is the function of the human rights in the protection of the environment. As we all know, under the convention that is applicable to the European Court and that is applicable in the area of Europe, states must take all appropriate measures to remedy and to prevent violation of human rights. And this is not only related to all kinds of damages that might be connected to the environment, but this is a general proposition, and this is how the court and the human rights in Europe function. As you all know, of course, the right to a sound and to healthy environment, it is not at the European level, at the level of the Council of Europe, it is not a self-standing right. But the protection that we are getting for now is going through the human rights. So in a way, we have still anthropocentric approach to the protection of the environment through the human rights. But as we can see, and the development is there, and that anthropocentric approach, I would say, is slowly melting down. Nowadays, there is a significant risk, and we recognize finally that there is a significant risk to the environment, and that there is a significant risk to not only environment, but to the whole planet and to our own survival, and that we are actually in the state of acute emergency. Only a year and a half ago, if you would think back, there was almost nothing on that issue in the media. Nowadays, everybody is talking about that. And we are talking about direct and indirect consequences. And very often, we are dealing with the direct consequences, and still we are not giving enough attention to indirect consequences. But all that is connected, and holistic approach is warranted. So when we are talking about direct consequences, that we are talking about the consequences to the environment that we see, the deterioration of the environment that we see. But to all of that, connected is the poverty, the conflicts, the migrations, and many other issues. And it is impossible to tackle this without one holistic approach. So, for example, when we are looking what is happening at the level of the Europe and European Union, when we are talking about the Green Deal, I would say we still have too limited approach. We are too concentrated on protection of the direct influences and direct consequences and direct harms, and we are not maybe dealing that much with the indirect harms. If we are looking what is happening in last couple of months in the United States, you see that they are talking much more when they're talking about new Green Deal, they are talking much more in a broader spectrum in their Green Deal approach than Europe, to the extent that could be also related to the fact that Europe is dealing with many of these issues in a different way, and is already dealing with the poverty, with conflict in a different way than the United States. But we have to look at that in the holistic approach. So, for example, on the eve of 2020, the UNEP report warned that unless global greenhouse emissions fall by 7.6 each year between 2020 and 2030, the world will miss the opportunity to get on track towards 1.5 degrees centigrade temperature goal of the Paris Agreement. The emission gap report found that greenhouse gas emissions actually keep on rising instead falling down. They had risen 1.5% per year over the last decade instead of being decreased. The production gap report found that governments are currently planning to produce 120% more fossil fuels by 2030 than a safe global carbon budget would allow. Another recent UN report says that the world has missed the critical deadline of 2020 to safeguard biodiversity. However, the report also says that if we can scale actions up immensely, there is still hope for a future where humanity lives in harmony with nature, or better to say, where the humanity survives. Both reports warn us that policies we have created at national and international or regional level to counter climate crisis and environmental deterioration have not been implemented at the desired level and with the necessary speed. However, we also see some positive trends. For example, the production and supply of fossil fuels is entering the climate policy debate. We are talking about that a lot. Non-state actors, local governments, corporations, and financial institutions are increasingly committing to take climate action. For example, recently we were able to read that the main Australian bank has declared that it will not finance anymore fossil projects based on fossil fuels. Then climate change is becoming a key concern of voters. But then we can ask ourselves, looking at what is happening in the United States with votes and how they are distributed, to what extent and with what result. And then, for example, the 65 leaders wrote ahead of UN Biodiversity Summit a few days ago that we are in a state of planetary emergency. We commit ourselves not simply to words, but to meaningful action and mutual accountability. Yet, governments still subsidize businesses that damage ecosystems. On 2nd October, for example, first new deep coal mine in UK for 30 years got to go ahead. It will extract 2.7 million tons of coal per year. And that was approved by the courts. When policies fail, people turn to justice. Climate change, so we see, and policies are failing us all around. So climate change litigation database of the Sabina Center for Climate Change and Law at Columbia University Law School, which is run by the law school and Arnold and Potter law firm, has recorded, and if you go to the site, you will see 1,270 US cases on all levels, and 396 cases outside US related to the protection of environment. In the US, 79 are constitutional claims, and outside US, 39 cases are pleaded as human rights issues. So you see that this discourse of environment and human rights is quite alive, and it's increased from day to day. Policies may fail in different ways. Sometimes policymakers back the wrong technologies, lack ambition, or simply do not engage with potential emissions reductions. And all these failures are nowadays subject to litigation all around the world. However, you know, when such cases are coming in front of the courts, we are faced with many obstacles that should be resolved and that are gradually being resolved. One being locus standi, victim status, causation and how we are dealing with the causation, whether and to what extent foreseeability of harm is relevant to liability or judicial relief, which are appropriate methods of competing claims from states, communities, and individuals, which are appropriate methods for awarding remedies, what is the interrelationship of competing claims from states, communities, and individuals, limitation periods for claims, jurisdictional reach of domestic and international courts to adjudicate climate change cases. When we are coming to the European Court of Human Rights and the role of the European Court of Human Rights, we can see that the court already has developed quite extensive case law in the area of the protection of the environment. However, as I have already pointed out, this case law is very much colored in anthropocentric words and approach. And this is to a great extent due that actually we do not have, as you well know, a special right to health environment at the level of the Council of Europe. The Convention on Human Rights is not providing a right like that. And what is court doing? The court is employing and using the interpretational methods to grant the protection and to extend and to interpret classical civil rights, civil and political rights, in a way that it encompasses the protection of the environment. However, there are limits to doing that, because that means that the protection of the environment has always to be connected to the protection of the individual human right. And this is really posing the question for the way to go forward at the level of the Council of Europe. And this is extensively discussed nowadays, whether that issue should be left to the court and whether the court should be left to develop incrementally jurisprudence in that respect, using the convention as the living instrument, or actually politics should step in and the convention and the protocol should be enacted. And I think that from what we are seeing, the Council of Europe is in past year moving strongly in that second direction. And I'm quite hopeful that in the future we will see the protocol and we will see the conventions. The convention on the criminal law approaches is already there and should be revived. And other conventions could come in as well. Of course, it is not enough just to enact the protocol, which would say, as most of our constitutions in Europe say, that there is a right to health environment, because this is not solving much. Of course, this is giving the direction. This is, I would say, freeing the hands of the court in interpretation of different issues, but still it's not solving the urgent issues that are in front of the court, and they are related to how wide is the access to court, and the issues of the victims, the issues of the burden of proof, and different issues that I will later on go into. So if and when, I would say when, the protocol would be created, and I hope it would, then it should also deal with certain issues that the court has already developed to a certain extent, but the protocol should go further and give solid basis, not just guarantee the right to a health environment, but should provide solid basis for the court, that the court can deal with these issues. Of course, if the protocol would not do that, the court would do that by itself, but this is always more difficult. Why it is more difficult? Because of the doctrine of subsidiarity and because of the doctrine of the margin of appreciation and the extent to which the court has, how would I say, limited possibility to develop at certain point, and really has to go incrementally, and it would be much more preferable if that could be solved through the international document. So what is the court nowadays doing? As I have said, the court is using the doctrine of the living instrument. And the court is using the international documents that already exist. And the court is doing that not only in the area of environmental protection, the court is doing that in general, in whichever topic the court goes into. But of course, when we are talking about environmental issues or some new technological issues or some other areas where the developments in the society are so intensive, then the court is using living doctrine much more frequently and more extensively. So we could see, but I must say, you know, when we have discussions, this is from the inside, when we have discussions on different issues, you could see a lot of confrontations among judges, and some are more conservative and some are more progressive, and the willingness to push the things and to go forward and to change and to overcome certain obstacles. So that's why I am saying sometimes it is better to go, and it would be faster if we go with the international instrument in that respect. Of course, if the protocol is not there, the court is using other international instruments, because when we are interpreting the convention, we interpret convention always relying on other international instruments. So, for example, whatever at the international level is developed, either as a hard instrument or as a soft instrument, the court will look at that, and the court is looking at that. Sometimes we don't cite. But even when we don't cite, you can be sure that we have looked at it and we have discussed it. Then we start to cite, especially soft instruments. Sometimes we would not cite, but we would draw the inspiration from the soft instruments. Then we cite the instruments, hard and soft. And sometimes we even relate to them when we are providing our argumentation. Very often, most frequently, we just cite and we do not use them in the legal argumentation, referring to them directly, but we are using the language. And sometimes we rely directly on international instruments. But for the development of the human rights, these other international legal instruments are also very important, and the court is taking cognizance of them. Then, while we are in the environment as we are now, where there is no specific right, then if you are looking what the court is doing and under which articles most commonly the issues are coming, then that would be under Article 2, under Article 3, Article 6, Article 8, Article 10, even Article 11, Article 1, Protocol 1, protection of the environment. When the court, protection of the property, when the court is dealing with these issues, the court is dealing under the procedural, because under the two limbs, under the limb of the protection of the procedural rights and under the limb of the protection of the substantive rights. And when we are talking about the procedural rights, then the court is developing jurisprudence under the fair trial rights, under the Article 6, and under the civil limb of Article 6, because the court has recognized that the environment, healthy environment, and issues related to the environment constitute civil right. So we are looking under the civil aspect of the Article 6. But more and more frequently, the court, when it is developing the procedural rights, is actually looking under the procedural limb of the other substantive rights, like Article 2 procedural limb, Article 8 procedural limb, or Article 1 Protocol 1 procedural limb. Actually, in past 10 years, the court is developing procedural limb of almost every and each substantive article. And when the court is developing this procedural limb, its primary concern is actually protection of victims' rights. And that's really very interesting when we are looking at that aspect of the procedural limb, especially when and if we are talking then about the protection through the criminal law mechanisms. Because when we are talking through the criminal law mechanisms, and if these criminal law mechanisms are then treated by the court later on, then the protection of the defendants would go through the Article 6, but the protection of the rights of the victim will go through the procedural limb of the substantive rights, which is really very interesting, and it is area in very strong development in past few years. When we are talking about the procedural rights, then we are talking mostly, I would say, about the right of access to information. And then this is something we are dealing under Article 10. Then access to the justice or access to the court, and under which conditions and when there is the access of the court and how to protect the access to the court. And then we are talking also about the right to participation in decision making, and this is then dealt under the substantive rights procedural limb under the different articles. The right to participate in the decision making that is related to the environmental issues. And then, of course, we are talking about the fair trial rights. The different applicants would come to us and say, well, certain fair trial rights have been affected while they were conducting proceedings at the domestic level. And then the other aspect that is developed is development of the substantive rights. And substantive rights, then we are usually talking about the positive rights, and these are the positive rights to the protection when there is a harm. And then there is a big issue, you know, how we define and which moment actually the protection and the positive obligations of the state arise, and that is different under different articles. So the standards that the court has developed are different under different articles, although they are, I would say, they are quite similar. Well, maybe I can address now. No, I will leave that for later on if we will have time. I will look at that if we will have time, or we can discuss while you are posing the questions. And please let me know when I have to stop, because I'm not I'm not checking the time, but I see. I would like now to address a couple of issues that the court is facing dealing with environmental issues and problems that the court has to be, how would I say, on the front, to be a real leader in this respect. But if we are, very often we are reapproached for that. So the court is quite cautious often, but sometimes we are not, as you can see from our jurisprudence. So what are, you know, the issues that we have to deal with? One thing that is really important for the applicants when they are coming in front of the court and they ask for the protection is the legal standing. Who can come in front of the court? When you can come in front of the court? As we have said, it is a civil right, whatever it is related to the protection of the environment. But Article 34 is quite clear on that. Only direct victims could come in front of the court, and the court will deal only with the cases of direct victims, which poses a significant problem for the litigation or for the applications that are related to the environmental harms. If you want your case to be dealt with the court, you have to demonstrate that you are a direct victim, so that you have been affected by the harm, and that there is a specific, serious, and imminent danger for you. Of course, with time, the court is trying to relax that requirement in different ways. But this is the first and basic premise, that you have to be a direct victim to be able to come in front of the court. The other thing is that the court is not there to deal with the collective litigations, to deal with the, now I escaped my, to deal with the litigations where NGOs are coming and want to protect some general right to the environment, want to protect, and are coming with the general issues where they cannot claim that they are directly affected. The court could relax, the court could say, and we have cases like that where the court is saying, look, there was the members of the NGO are directly affected because they are living in a certain area, and then the court is ready to accept the case, and the court is trying, you know, frequently now to find the ways how the court can grab the case. But still, you know, the basic line is there, that you have to be a direct victim to have the standing. Public interest litigation is excluded from the jurisdiction of the court. There is no actio popularis. The question is, you know, whether it is possible for the court to overcome that. And this is quite a serious issue, and this is one of the issues that if the Council of Europe and if the states will come with the new protocol, that I think it is crucial to be addressed in that protocol, and that would then free the hands for the court and to deal with environmental issues more frequently and would be able to go more in depth. And that should be really, you know, taken into consideration when the document is drafted, and if it will be drafted. However, there are already the possibilities, you know, to open the door, because the court has opened the door in one very specific area. And this is and then the court could try to apply that mutatis mutandis, although the court has not started to do that as of yet. This is the case line related to secret surveillance, starting with Klaas versus Germany, Kennedy versus United States, Zakharov versus Russia, and now the same issue will be addressed in the Big Brother Watch case that is in front of the Great Chamber. And there, in that area, the door was slightly open, and so, you know, you always can use it mutatis mutandis, and I think that environmental issues are keen, you know, for this mutatis mutandis application. But of course, this is to be seen in the future whether it would be done in this way. Then it is also, in terms of legal standing, problematic is that, for example, basically legal entities could not come and ask for the protection of the rights which are perceived as strictly individual rights. For example, if we are talking about the under Article 8, protection of private life and the protection of home, their legal entities could not come. The court would say, no, this is outside. They are not victim. They are not satisfying the criteria of the victim status, and the case would be out. However, the court started. The special issue, actually, put it like this, the special issue is, for example, how far all of this is applicable when we are talking about participatory rights. So when we are not talking about the protection of the substantive rights, right to life, right, I don't know, right to privacy, right? But when we are talking about the participatory rights, so when we are talking about, as I have said, access to justice, access to information, participation in decision making, there the question is, you know, whether there as well, harmful effect, direct harmful effect has to be proven for the, for example, NGOs to come in and to protect these rights.
Ksenija?
Yes.
We have 5 minutes.
How much I have? I will just say what I have 5 minutes, I think.
5 minutes, and then we have the discussion.
Okay, so there are following issues that are really problematic and important for the court are harms and causality. Harms and causality, and very high threshold that exists there under Article 2, under Article 8, and it's very often preventive for the applications to actually be looked at the level of the merits, and you know the case go out already because there is no because of the high threshold that is related to the imminent and serious danger. Very often serious danger is that, but imminency of the danger it's very questionable, and how that should be used in environmental cases also, because very often we have long-term effects, and then how court can incalculate long-term effects and deal with that. So when we are in the Article 6, what is required, this is the direct link and causality between alleged environmental harm and the alleged human rights harm to be able to use Article 6. In Article 2, what is required is imminent and clearly identifiable hazards, and when we are in Article 8, what is required is direct or sufficiently close links between risk and harm, so the court relaxed a little bit. And then if we are looking at very recent case law, and there was an interesting case in front of Section 1 last year, Cordella versus Italy, where the court relaxed even more under Article 8, and it has opened the door for looking at the probabilities and at the statistical data and then using that when we are looking at the causality and sufficiently close link. But certainly this is one area that merits further development, and that will be a big thing for the court in the future, and how the court will deal with these issues. Fourth issue that is very important, and where the court is developing, and environmental protection requires certain specificities, is the balancing of interests. Because as we know, in this area as well, different interests are coming and they might conflict. Interest between individual persons, interest between the state and the individuals. And then what is the most important, I think, and in the world is not paying enough attention to that issue as of yet, or we are thinking about that maybe in a wrong way, is the balancing of interests of the protection of the environment and the economical interests. If we are looking at the sustainable development, we see that there are proclamations that these two issues are of equal value and of equal importance. It is stated that you cannot, and it is in our case law as well, that you cannot just take economic interest and because it is there, say that you will trump environmental interests. But the question is, if we are insisting on constant economic growth, whether that could be in a way reconciled with the protection of the environment and limited resources of our planet. So this is something that really, when the court is developing the case law related to balancing of different interests, will have to be in the future taken seriously into consideration, and it is not paid sufficient attention to it, not only at the level of the court, but at the level generally. And then at the end, the issue that is very important is the issue of the redress and the way, you know, how the court is providing the redress. And here the court, European Court in general has problems, I would say. It is too much concentrated on Article 41, which is related to just satisfaction, and many cases are just ending by the just satisfaction. But obviously, this is not something that would be sufficient when we have environmental cases. First of all, what we have now is that in most of the cases, the remedy is related to the individual. And when we are talking about the protection, we need more to concentrate on general measures, but we have the possibility to concentrate on general measures. Of course, the court is not the one who is usually proclaiming which general measures have to be undertaken. In a way, the court is lucky and unlucky because of that. This is left to the Committee of Ministers, and Committee of Ministers is doing that together with the state party that has been found that violating certain rights. And the Committee of Ministers is there then to supervise and the way in which general measures are implemented. But if the general measures are not implemented in the right way, not in the area of environmental law, but in other areas, we have seen recently that the Committee of Ministers could come in front of the court and then ask for the judgment to see, you know, whether the state has complied in the right way with the remedy that was given and that was pronounced. So these are like areas for the court where the court might have problems, and where for the court would be very important and very helpful if the international instrument would be developed and would solve in part these problems, could not completely, and give a boost and open the door for the court wider to entertain these issues and deal with them. And then I didn't go into it, but positive obligations of the state, and we have seen, and the obligation, you know, to prevent harms, and we see very important development going on now in front of the court. It is not directly related to the environmental cases. It is related to different kinds of cases, from domestic violence to, I don't know, traffic accidents to whatever, whether Osman test could be applied or should be relaxed in order that positive obligations could be properly implemented. And I think we will see gradual relaxation of the Osman test, which will have positive effects on environmental cases as well. So I will stop here and then you can ask me questions.
Okay, so thank you very much for this very instructive oversight on the European situation. Maybe we already have a number of questions. Your last point, I think, addresses many of the questions, the positive obligations of the court. Really to say the states have to actively do something to prevent it. We just not wait until some harm is done, but you as a state have to prevent it. I mean, this is a bit more clear when it comes to the protection of direct life or liberty, but how far do you see the possibility that a court can really develop in the environmental sphere this approach, so that we in the end have a kind of environmental protection obligation of the states that very specifically says maybe also you have to criminalize certain acts that violate the environment?
Well, I think for the court, this is not so difficult. We already have developed the mechanisms for that when we are talking about the positive obligations, because when we are talking about the positive obligations, then on the one hand, you know, we are talking about the legal framework and the establishment of the legal framework, then the implementation of the legal framework, and we are talking, on the other hand, about the different procedural obligations. And what you are asking me is actually legal framework and broader when we are talking about the environment policy framework as well, because the litigation that we see at the domestic level is often related to legislation and to the policy and to the standards that the state is establishing, with the question whether the standards are high enough, or if they are high enough, whether the implementation is fast enough. So these are the issues that we see. If we are looking, in front of the court, you take the issue of the domestic violence, or most recently, you take the case with the trafficking of human beings, or prostitution or whatever, and you go and you look at that case law, you could see how much and how deep the court is dealing with the legal framework. And the court goes in, the court looks whether the right legal framework is there, whether this legal framework is in accordance with the international obligations, whether this legal framework is following the consensus, if the consensus exists there at the European level. And then if that is not there, the court is even giving the direct, instructions in terms by saying what is failing, what is not there, what is in this way the court is giving actually the instructions how the framework should look like. So there is nothing that would prevent the court to apply mutatis mutandis the same approach when we are talking about the environment. The truth is that, for example, up to now, the court has never mentioned Paris Accord, for example. But the court will, there is no doubt that the court will. And lots of things also depend upon the kind of the cases that are brought in front of court. So the right case has to come in front of the court, and then the court can say the right things. And of course, for the right case to come in front of the court, that case should be litigated in the right way in front of the domestic courts. And that is the most important. For example, for the case actually at the end to be entertained by the court, for example, we were all, it was interesting for us. Of course, we were all following the case that went in front of the Dutch courts and the case that went in front of the Irish courts, because we were aware if these cases would end in a different way, they would come in front of us. They ended as they ended, they would not come in front of us, but other cases would. In September, we got the case that was filed by youth of Portugal, and it is directed against a number of European states in terms of the level of the emissions and the standards that are set by the states. The big issue and the first obstacle and the hurdle that will have to be overcome in that case, which is in itself very interesting for the court, I believe, is admissibility. And when we are talking about admissibility, it is the victim status, as I have said, and to what extent we can say direct victims. And on the other hand is the issue of the exhaustion of domestic remedies. And that is the biggest hurdle. The domestic remedies really have to be exhausted impeccably, because the court is insisting and the states are insisting on the subsidiarity, and the court is very strict nowadays on that. So I'm saying that as a warning, the case really has to be done properly at the domestic level, and then it is coming in front of us. Dealing with the legal framework for the court is not posing a problem. We have already developed mechanisms and the base how we are doing that in other areas.
Okay, so thank you. Well, then we go through the questions as they came up. First, Ivana, maybe you post a question because I'm not sure everyone reads, or maybe I can just read it out to you. Okay, so the first question was, do you think that the growing media attention and pressure from influential people like Greta Thunberg has led the court to take greater action in resolving environmental cases and understanding the importance of the topic in general? Has it contributed to better solutions, faster decision making, any improvement in the work of the court? So that's the first question that came up.
Yeah, well, but certainly, look, the court has its list of priorities. You know, our cases are divided according to the priorities. And for example, for now, we divide cases in 7 categories. And then the category from 1 to 3 are so-called priority cases. And these priority cases have to be dealt within a certain period of time. And this is at most 2 years when they come to us. And then in the priority cases, we have different kinds of cases. For example, the cases that are dealing with certain articles, like Article 2, Article 3, Article 5, Paragraph 1. Then these are the cases that are posing leading issues. So, you know, environmental emergency now, in the way as it has been put in front of us and as it is, it's obviously within the 2 priority group, and that means that these cases are dealt immediately, you know, and we are communicated immediately, and then they have to be solved fast. Of course, this is not, you know, like the media. It is not the direct influence on the court, I would say, not direct influence, but this is indirectly, because, you know, everybody is taking the action. Everybody, you know, we all are becoming more aware. I hope we are all becoming more aware. And of course, this is reflected in front of the court as well.
Okay, so next question was from Lara. Where does the jurisdiction of the European Court of Human Rights to resolve environmental issues derive from, since the convention doesn't enshrine any right to a healthy environment? Maybe you just sum up.
I can just sum up, because I was talking about that. This is related to the classical civil and political rights, and we are deriving that through interpretation of the classical civil and political rights, usually through the positive obligations. When we are talking about some substantive rights and procedural rights, you derive directly, you know, because there is no difference. Procedural right, what is in substance is not different for the way how you apply the procedural rights. Usually, what could be different is, you know, whether you relax the, for example, approach to the victim status a little bit, or you relax the approach to the causality, or you relax what we are seeing in the area of the environmental cases, that the court is relaxing these strict approaches sometimes because of the nature of the case, because of the nature of the topic with which the court is dealing.
Okay. Very interesting. And then the next question from Marisha was, how frequent are the cases from Croatia and about environmental rights to the European Court of Human Rights, and what are the main reasons? Well,
I would say, unfortunately, I would really happy to get a Croatian case that is related to the environmental rights. We had some. For example, one of the first cases of the court on noise pollution was actually the first case, I would say, on noise pollution a few years ago, was Croatian case. Then we got one very interesting case, and I thought it would be a big case when it arrived. And the name was Turković versus Croatia, and everybody was asking me, are you related? But I was not. It's just the same second name. And it was related, and people from Croatia know, it was related to the waste place close to Zagreb. But unfortunately, in a way, it was not pleaded in the right way. So it was not possible to. So you see, it is so important. Sometimes you get a case and you are so, I won't say angry, but you are disappointed as a judge. Judges are disappointed because they get a good topic, but they are not able to do with that topic anything because the case is either not pleaded well in front of the domestic courts, and most frequently that is the case, or when it is coming in front of us is not pleading in the right way, but there we have some, you know, possibilities to correct. For example, if it is pleaded under a different article and the court thinks it should be pleaded under another article, we can do that under the court knows the law, But, for example, if factually it is not well established, then we cannot do anything. So, you know, should be very important. So there was this noise case, this was this, and basically that was it. We didn't have other environmental cases.
Okay. And then a question from Ivanka, and we have to close the list then quite soon. I saw Maya was already and Nicola. Yeah, well, I have the next questions from Nicola now coming, and she asked which specific international instrument are the most often looked upon when adjudicating cases related to the environment, and connected with that, what is your impression? Has the environment been protected enough for government's implementation of decision regarding the direct harm to the individual?
Yes, well, I didn't have time. I wanted to do that, but it takes some time and I don't have that time as a judge to check how often we are citing certain documents. But you can go to the HUDOC you put in and you can do it easily. It will take you 1 hour and you will have the info. I didn't have time to do that, so I cannot give you the info. But I told you that we are citing frequently, depends upon the issue that is coming in front of the court. When the issue is coming in front of the court, lawyers who are preparing the drafts are always required to look, regardless of the issue that we are dealing with, to look at all the soft or hard international instruments. We have our research department when we are dealing with the grand chamber cases. Research department is always involved. We gather research if the topic is of that character. We gather research on the international law. We gather research on the national laws. We get, you know, all kinds of researches. We get third-party interventions and so on. So the court is very well informed. And so sometimes, you know, the frequency of the citation of certain international documents would actually depend how frequently certain issues have appeared in front of the court, you know, because you have specific instruments protecting this or protecting that. But the court is really looking. And then the second question was, yeah,
on the if the government's implementation of decision regarding the direct harm to the individual this has been the environment protected enough by using this instrument.
Well, but that doesn't pose the problem. You know, if you have a direct effect on the individuals, that is the easiest possible case. You know, you have the direct, then you don't have only the violation of the environmental right per se, let's say, but you have the violation of the human right. And when you have that connection, then for the court it's really easy to go in and to find the violation if the violation is there, and the implementation is in this respect quite easy, I would say, for the Council of Europe. The question is whether in a case like that you have the violation that is really limited to that specific individual, and then you will have individual measures, or you can say that this is a broader issue there, and then the court hints that there is a need. Sometimes the court goes directly and say this and this general measure under Article 46, but the court is not keen in doing that because the court believes that there should be a sufficient flexibility for the Council of Ministers and Committee of Ministers and the state to negotiate what would be the best way to approach the issue and to solve the issue that the court has, you know, pinpointed. But sometimes court does that, gives the general measures that should be implemented. So, you know, the more difficult problem is when there is indirect danger or when you have long-term effects, and then on which basis the court and what level of proofs need to be there for the court to go in and then for the courts to find the violation. And what is discussed is actually whether in this area, as in some other areas, we need actually to be able to shift the burden of proof on the state to prove that it was not possible to provide protection. It was not possible to secure, you know, and to implement positive obligation, but we are still not there. But I think this is something that in the future will come.
Then we have two more questions. First, Maya, you.
Okay, just very briefly with Professor.
Hey,
It's
Maya.
wonderful. Hi, it's wonderful to see you even via Zoom. So anyway, it was a wonderful, thought-provoking lecture full of information, at least for me. I'm not really an expert in environmental law at all. But what I was thinking is, okay, I'm not denying the moral authority of the court and importance of the court decisions. But in the first part of your lecture, you addressed the urgency of the matter and the policies that needs to be implemented if we want to achieve the goals that have been set. And in my view, I mean, if we look at the difficulties with which the court is fraught, like what is the indirect harm and the indirect victims, and anthropocentric approach in itself is posing a lot of problems. There are, I think that, I'm not denying that it's important what the court does, but we need to do much more. That's my view. And I recently read that human beings and livestock make 96% of all the mammals on Earth, which means that we and what we eat is basically like we are destroying completely biodiversity of the planet. And unless we leave this anthropocentric approach, really, I can't see any meaningful change being made. So that's my comment. Maybe I'm completely off the. But
no, I think it's an important comment, and it is reflecting the reality. You see, the courts are far too slow. The courts are far too slow that you would rely on courts to solve the problems. You know, the courts are there actually somehow to correct, to direct. They are anyhow coming very often ex post facto. You know, of course, what we are doing ex post facto, as a criminal lawyers, we very well know that it has a preventive function as well. But really, what we need is a holistic approach. That is what we need, and we need the courts to be there, but we need a very strong executive, and we need legislatures that are legislating. And then, as we have said, the court is there if the things are not going right, and it takes time for the court. You know, we are really trying now to improve the timeline of the cases, and we are doing immense things, you know, to do that. But sometimes, recently we had in a Grand Chamber case that was from 2004, I believe. So, you know, we are in 2020. So it came into court in 2004, and it was litigated beforehand at the domestic level. So it took, I don't know how many years, you know. So we have to, of course, rely on the other mechanisms, and the court is here, I would say, subsidiary. It should not be on the front line, but it's actually to boost, to reinforce, to correct, and of course all these problems that we have are preventing the court maybe, you know, to react promptly and to react widely enough. And as long as we are standing with this, that the environment is protected through the human rights as individual rights, without having environmental right as intrinsic right in itself, then this anthropocentric vision is preserved. Of course, it is relaxed, and then you are taking, and we have already cases, for example, where we are protecting biodiversity, for example, in itself, without looking at to what extent the humans have been affected. So we have cases like that. So the court is moving by itself in that direction. But still, as long as you don't have it, this anthropocentric and this connection to the violation of the individual right will be there. And will be to a certain extent prohibitive, you know, to go as far as sometimes is needed. So yeah, it is very important. And then, for example, if we would get the intrinsic right to a healthy environment, that would affect also the extent to which we would interpret individual rights under Article 2, Article 8, or Article 1, Protocol 1 in the anthropocentric way. That would free these rights in itself from you know, to be more to be more ecocentric related, and so on. So this is all very interrelated.
Okay, then one last question coming from Bartol. And well, it's already leading to the other subjects we are having in the next two presentations. So and he's asking, while a law of ecocide could be used to hold individuals who cause specific ecological disasters responsible, it seems unable to address the wider environmental destruction caused by humanity at large. So who goes to jail, and how do criminal charges prevent further self-destruction implicit in the material self-reproduction of industrial civilization? So a very big question. Please.
This is my son.
Yeah, I know.
And we discussed that in private. And I was asking him to help me with the lecture today, but he didn't want. He wrote something for me, but I didn't have time to go into it. But I hope we will write together on that, because he is really working a lot on these issues. Well, this is moving from the, and it is moving into your topic, and it's moving away from the human rights courts, because human rights courts are not dealing with the ecocide, and we are not dealing with criminal offenses. But this looks only in the first sight like that, only at the first sight like that, because and here I would like to point out, of course, you know, whether that will become the issue for the ICC, or independent courts should be created for something like that. This is like the same question that people are posing, whether the regular human rights court, like European Court of Human Rights, can deal with the environmental issues related to the human rights, or we should have a separate court that would deal with issues of human rights and environment connected, you know, that this is connected. So I'm leaving that aside, and that you will be dealing with when you will discuss, you know, how to deal with the international environmental crimes. But that the court will play an important role in this area, this is obvious, and this is certain, because if we are looking what is happening with the crimes, war crimes, crimes against humanity, and the way how, for example, ICC, first I would say national courts, ICC, and then our court are interconnected in this joint business. When you are at the level of the national court, the national court is not doing proper business, then the ICC is taking and appropriating the case. And then if, you know, and ICC cannot do more than that. ICC can just appropriate the case, but our court can do a lot in that respect, because if we have substantive violation of Article 2 or Article 3 during the war, you know, we have war crimes, we have crimes against humanity, we have actually the possibility to say, well, there was a violation, and we can do it much easier than ICC or national courts can do. Because for us, the burden of proof is lesser in this respect, if you would look at it. And especially, and we can do it through individual cases and intergovernmental cases, interstate cases. And we have a number of interstate cases like that now in front of the court. Ukraine, Eastern Ukraine, Georgia, and so on. And we are reinforcing the whole business in this respect, finding the violations where the domestic courts fail to find the violation. We are finding violations where implementation is not there, and we are able to give compensation. So, you know, the court is really performing. So in the future, if this will become the reality, having the international crime, the court will be there in the backstage to reinforce all the, you know, to reinforce where failures are made. And that would be, and that is really very important than holistic approach. So we look as not being criminal court, but in a way, you know, we help a lot to criminal court.
Okay, so thank you very much, especially for this good overview and connection between the human rights and the criminal sphere. I think we will see that a bit more in detail than in the next two discussions. First, I thank you very much for this very intrusive, very detailed and very instructive talk and insight into the courts of human rights. And I think we can really clap our hands for you.
Thank you.
And